Checking to make sure my audio is working. Checking to make sure my audio is working. Hey YouTube, it's your girl Duchess, and I'm back hitting this live quota. I'm back for the third time today, and we're going to talk about the YSL case. Today was the last day of filing motions for both the defense and opposing counsel. The prosecution and opposing counsel, the defense. Today was the final motion, and we are going to get into a few of those motions today. You guys will hear some raining in the background because it has started to rain where I am. But girl, that administrative work ethic showed up on me, that spirit. And I couldn't let it rest. I ended my live earlier. We were talking about the Kamala Harris case, and I was like, dang, the deadlines were due today. Court resumes next week for them to hear them. And I want to check it out. So since I'm checking it out, I am bringing it to you guys too. I hope you guys are well this Tuesday. Don't get concerned if this is not your kind of content, because I will be back with my reviews tonight as scheduled all the rest of the week. But we are a well-rounded channel over here. And until you guys tell me to cut it out, I am bringing the lives to you, and I'm getting more comfortable and kind of enjoying the space. So I appreciate everyone that drops in to hear these things out. And without further ado, we are going to get into my first motion. All right, let me pay attention to what I'm doing here. I'm going to give you guys some music, and I'm going to get set up. That ain't the music that I want. That ain't the one I like. This is the one I like. Yeah. It's a good Tuesday, you guys. I hope you guys are feeling good out there. Hope everything's going well in your week. I hope you heard my advice that if it is not, get in your closet and get in God's ear. Just talk to him like any other person you would talk to. I mean, you want to be respectful, but he's got a responsibility to us. We just got to make sure we hold our responsibility to him and his people and the body of Christ. That's not why you guys came here. If you showed up at all, I'm getting fine with it. I don't even worry about it anymore. I'm just praying my subscribers hold up. So, and that I continue to gain momentum. I have a goal this week, you guys. I want to hit 300. I want to hit 300 this week because I got plans for this channel. But right now, we got plans to get into the YSL case and the motions that were filed. Because not only are we getting ready to enter out, duke it out, scrub it out, thug it out for the presidential seat for 2024, Georgia has some corruption to handle down there, and we got a new judge on the scene. She didn't come to play. So let's get into these motions that, oh, listen, I'm just talking. I have figured out how to show this in full screen. I don't know if that did it. That looks like for you guys. Let me check really quick here. Um, and see how this is presenting this way. Oh yeah, I like that. Oh yeah, I like that. All right, you guys. So, okay, you guys. So we are getting into some of these motions today. Today was the deadline. Today was the deadline for all the motions for the YSL case today. Next week, the judge will hear them on the 30th, promptly at 8:45. I will be bringing you guys that news as soon as I can get to it. Um, I'm enjoying this space and bringing this kind of content. We will still get into, excuse me, get into our reviews for sure. Excuse me, let me get a little water. But I'm just interested. We are gearing up for a knockout, drag out, thug it out presidential candidacy race. President, Vice ex President Trump has kind of called the Democratic Party to the table, and they have answered, honey. They got Kamala Harris on the bat phone, and Georgia Fulton County court system is fighting to keep their skirt from hanging and being dragged out here in exposure land. I mean, they already out there, but they trying to redeem themselves. So we have Judge Whitaker on the bat phone, and there are some motions that are being heard. Well, I'm sorry, that were filed today. So here is the first motion. And I don't like the way that's looking because I can't scroll it. Or maybe it is. Hold on, y'all. Yeah. Okay, hold on. Y'all know I be. Lord, did I click out of my whole thing? I did not. All right, so let me see what you guys. Well, I'm messing this up. All right, let me get my life here. Okay. Bear with me, bear with me, bear with me. Okay. So we have our first document here. In the Superior Court of Fulton County, State of Georgia versus Shannon Stillwell, defendant Judge Whitaker, motion for reconsideration regarding certain hearsay statements. Let's get into it. Comes now Mr. Shannon Stillwell by and through undersigned counsel hereby files the motion for reconsideration in above style case. In support of this motion, Mr. Stillwell shows as follows. Mr. Stillwell is accused of multiple felonies, including count one, conspiracy to violate the Georgia RICO law, and specific substantive felonies. Mr. Stillwell is innocent of all the charges against him. Mr. Stillwell is charged with the January 10, 2015 alleged murder of Donovan Thomas. In count two of this indictment, Mr. Stillwell is innocent of that charge as well. Kenneth Copeland, a witness called by the state, there's Lil Woody again, is currently on the witness stand. Mr. Copeland has never claimed to have any firsthand knowledge regarding the death of Donovan Thomas. Mr. Copeland did, however, meet with law enforcement several times in 2015. On June 10, 2015, in what was Copeland's fifth meeting with law enforcement in 2015, Mr. Copeland told law enforcement that he possessed specific information regarding the shooting death of Donovan Thomas. Mr. Copeland made this claim while under the threat of arrest for unrelated crimes that law enforcement was investigating. Mr. Copeland did not mention this information on any of the four prior meetings with law enforcement. In his June 10, 2015 interview, Mr. Copeland told law enforcement that he picked up Demikian Garlington at a McDonald's restaurant on Cleveland Avenue on the evening of January 10, 2015. Copeland reported that Garlington walked to his Copeland's car, and while the two men were briefly alone, Garlington told Copeland that they killed Nutt. Copeland told law enforcement that Garlington then pointed to a group of people who were pulling into the McDonald's. Copeland, yeah, as I'm reading this, I could just see Lil Woody because he already told us that he'd be lying to get out of stuff. But anyway, I'm sorry. I just got a little chuckle there because I pictured it. Copeland told law enforcement that he interpreted Garlington's words and actions to mean that Mr. Stillwell, Mr. Kendricks, Mr. Justin Cobb, and Mr. Demise McMullen, or they may be Demise McMullen. I hope no one didn't name their child Demise. Oof. Oh, we're all present for and all participated in a drive-by shooting of Donovan Thomas. Per Copeland, Demise McMullen entered his car shortly after Garlington and all communication about that event ceased. Mr. Copeland is now a sworn witness for the state and is currently on the stand. On direct examination thus far, Copeland has denied making this June 10th, 2015 statement to law enforcement. Mr. Copeland has repudiated the contents and veracity of this prior statement. However, Copeland testified at trial that this conversation with Garlington never occurred and that he, Copeland, fabricated the event to get himself out of legal trouble. He did say that. Furthermore, Copeland has denied contextual clues surrounding the out of court statement, testifying that it was Mr. Stillwell and not Mr. McMullen who got into the car with Copeland and Garlington that evening. Stillwell has challenged the admissibility of Garlington's out of court statements on hearsay, that confrontation clause grounds. Judge Glanville, who has since been recused from this case, ruled that these statements were admissible as statements of a co-conspirator. This ruling does not comport with the U.S. Constitution or the Georgia Rules of Evidence. The plain text OCGA, y'all see the letters, requires not only that the proponent of the evidence establish the existence of conspiracy and to show that the statement was made during the pendency of the conspiracy, but that the proponent must also establish that the statement was made in furtherance of the conspiracy, assuming that Garlington actually said these things to Copeland. These statements were not made in furtherance of the conspiracy. To find otherwise simply overlooks, disregards the plain language of this case, OCGA, that law that they have, and the line of controlling cases that establish statements that spill the beans, by definition, do not further a conspiracy. See generally Stafford versus State, State versus Lane, State versus Wilkins, U.S. versus Blakely. Mr. Stillwell, through undersigned, this is a footnote, attorney, filed a motion in limine on this matter on September 30th, 2022. Judge Glanville eventually considered brief argument and ruled on admissibility of the statements. Defense counsel was unable to locate a written order regarding the admissibility of Garden's alleged statements. Garlington has never publicly acknowledged making these statements to Copeland, and that Copeland now denies that Garlington ever made these comments to him. The state plans to elicit testimony from Copeland regarding the Garlington's alleged statements. While Copeland is now denying that Garlington made any such statements, Copeland has openly acknowledged that he previously told law enforcement that Garlington made said statements. The state has attempted to improperly introduce the contents of Garlington's statements through recordings of Copeland's prior statements. We're going to come back to that, y'all. There's already a motion on file for that. Well, let me just take a brief moment here. So there's already a motion about the introducing the contents of Garland's statements through recordings, because in the trial hearing last week, where the judge scheduled for everybody to kind of catch up, and it was only the attorneys there, Brian still put on the court record the law that once a judge is recused, everything thereafter is kind of squashed. And so before they introduce the evidence of the recordings from the interrogation video. Before that, they had filed for Judge Glanville to be recused based on that infamous ex parte hearing that we keep hearing about. Judge Glanville heard that order and denied it, but the Supreme Court got involved, and so now here we are. So I just took a little break to kind of bring us back to that because it looks like this may be approved, y'all. They gonna get these boys free. That's what I think. I'm not an attorney, but that's what I'm thinking. All right, let me get back to where I was. Okay, so the state has attempted to improperly introduce the contents of Garlington's statements through recordings of Copeland's prior statements, including his June 10th, 2015 interview. The state's method is improper for two reasons. First, Copeland has not denied making these prior statements, and therefore no foundation for prior inconsistent statements has been laid. Ooh, that word just gives me PSTD because they heard that. I heard that so many times when they were hearing this case. Second, which is the focus of the motion, Garlington's statements to Copeland, even if uttered, were not made in furtherance of conspiracy and therefore failed to meet the requirements of that code, Georgia Code, of judicial process, whatever that. Wherefore, undersigned counsel respectfully requests this court considers Mr. Stilwell's arguments and reconsiders whether the state has met their burden in establishing that Garlington's alleged statements satisfy requirements. That's a huge motion. Respectfully submitted. That's a pretty big motion, guys. That's a pretty big motion. Interesting. That's a pretty big motion. Because if that motion is granted, then Lil Woody's testimony may not even be a part of this trial, and that's supposed to be the star witness to kind of get this thing going. So let's move on to the next document that was filed today. Uh-oh. Y'all ready for this? This is some of the state's filings. They fighting back. All right. Let's get into it. All right. State's motion to restrict extrajudicial statements. State of Georgia versus Jeffrey Williams, Judge Paige Reese Whitaker. State motions to restrict extrajudicial statements. Come now, the state of Georgia, and moves this honorable court to instruct the defense to refrain from making further extrajudicial statements about this case moving forward. Georgia Rule of Professional Conduct, Rule 3.6. Oh, they want to cite some rules now? All that stuff they've been violating? I mean, I guess they got to do their job, but that is just interesting. Prohibits lawyers participating in litigation from making extrajudicial statements a reasonable person would believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing and adjudicative proceedings in the matter. A relevant factor in determining prejudice is the nature of the proceeding involved with criminal jury trials being the most sensitive to extrajudicial speech, the character, credibility, reputation of a party, and any opinion as to the guilt of innocence of a defendant are subjects deemed to be more likely to have a material prejudice effect on a criminal proceeding. Defense counsel have made numerous extrajudicial statements explicitly about this case while a jury is sworn and seated during the state's case in chief. Defendants Williams' counsel, attorney Brian Steele and Keith Adams, Defendant Kendrick's counsel, Attorney Doug Weinstein, and defendant Stilwell's counsel, attorney Max Shard, have all made extrajudicial statements to the media explicitly discussing this case in violation of Rule 36. The extrajudicial statements have included, among other things, interviews and statements to the Associated Press. Four of those interviews have been 25, 33, 43, and 107 minutes in length. The statements include, among other things, the attorney's views and opinions about the case itself, opposing counsel, the now former judge, the jury, the outcome, and the guilt or innocence of a specific defendant. Pursuant to OCGA, courts have the power to control in the furtherance of justice the conduct of its officers and all other persons connected with the judicial proceeding before it in every matter appertaining thereof. The state must thus moves this honorable court to instruct the defense to refrain from making extrajudicial statements about this case moving forward. Exhibit A. Below, please find Brian Steele's statement regarding the recusal order. Jeffrey Williams is innocent of the charges brought in this indictment, and to clear his name, he sought a speedy trial, one in which he would receive the constitutional guarantees of a fair trial with an impartial judge proceeding and ethically prosecutors following the law. Sadly, Judge Glanville and the prosecutors have run afoul of their duties under the law. Mr. Williams is grateful that the reviewing court agreed with him and entered the order recusing and disqualifying Judge Glanville from presiding over Mr. Williams' case. We look forward to proceeding with a trial judge who will fairly and faithful follow the law. Oops, that's from Twitter. Exhibit B, exclusive. Young Thug's attorney speaks out on Glanville recusal. Keith Adams. Y'all, they over there in YouTube. They left a link in YouTube. Complete interview, 1512 to 55 minutes. Exhibit C, the Associated Press reached out to Glanville and to a lawyer for Young Thug seeking comment on Monday's ruling. A spokesperson for Willis' office declined to comment. While I respect Chief Judge Glanville and his service to this community and the country, he simply became biased over the course of this case. Kendrick's lawyer, Doug Weinstein, said in an email. He added that he looks forward to trying the case before an unbiased judge, but said the only just outcome at this point is a mistrial and bond for Kendrick, who has been jailed for far more than 2 years. Exhibit D, Judge Glanville recused. Attorney Doug Weinstein discusses live with journalist Megan Cuneff. Okay. Exhibit E, Young Thug trial, Young Thug YSL trial update. Megan interviews defense attorney Max Shard. Exhibit F, the debrief interview with attorney Doug Weinstein, YSL ex parte transcript, and recusal. In the Superior Court of Fulton County, State of Georgia, I hereby certify that a copy of the foregoing, this is a certificate of service, state motions to restrict extrajudicial statements was served via e-file to Brian Steele, Keith Adams, E.J. Apt, Doug Weinstein, Katie Hingurity, Maxwell Shard, R. David Botts, Curtin Matthews, Bruce Harvey, Angela D. Williams, the 23rd day of July, 2024. They're getting to it, y'all. They are getting to it. They are getting to it. Interesting. I'll be right back. Let me just see if there is anything else for us to share in this live. Give me a moment or two. Thank you for coming. Be right back. Okay, you guys, we got one more motion here. It is a motion for mistrial. And a few of the other attorneys kind of came in on the piggyback of that, but we have a motion for mistrial also, and I thought that that would be interesting. So here we go. All right. Diamante Kendrick's motion for mistrial comes now. Diamante Kendrick, petitioner by and through his undersigned counsels, and bring this motion for mistrial showing as follows. We think that in all cases of this nature, the law has invested courts of justice with the authority to discharge a juror from giving any verdict whenever, in their opinion, taking all the circumstances into consideration, there is a manifest necessity for the act or the ends of public justice would otherwise be defeated. They are to exercise a sound discretion on the subject, and it is impossible to define all the circumstances which would render it improper to interfere. But after all, they have the right to order the discharge, and the security which the public have for the faithful, sound, and conscientious exercise of this discretion rests in this, as in other cases, upon the responsibility of the judges under their oaths of office. Jones versus State. The state has had witness after witness fail to provide the testimony that it would like the jury to hear. Rarely in the recent history of Fulton County Superior Court has one party had to impeach so many of its own witnesses, including at least the following key witnesses: Trontavia Stevens, Walter Murphy, Archillian, as in Webb. The court can't repair the infringement of Kendrick's due process rights under the 14th Amendment, regardless of whether the violation was under the Webb and when Kendrick's rights were violated by the judge's intimidation and coercion of Copeland. As the state likely expected, Kendrick has now been graded, goaded into seeking a mistrial because of this due process violation and regretfully requests a mistrial. Wherefore, Kendrick respectfully and regretfully requests this honorable court to declare a mistrial based on the practical impossibility of voiding the case after June 12, 2024. The violation of Kendrick's rights by his being absented at critical stage of the proceedings and or for tainting of the testimony of Copeland by the improper coercion of his testimony by Chief Judge Glanville. Furthermore, Kendrick respectfully requests this honorable court find that this request for mistrial was goaded by the state when it requested that the Chief Judge Glanville hold the ex parte meeting, absented Kendrick from the meeting, and join with Chief Judge Glanville in the coercion of Copeland. All right, that is interesting. That is interesting to me because in that recusal hearing, the judge that ruled on that case, she said that the only infraction, the ex parte meeting was not illegal. There was nothing wrong with the ex parte meeting. There wasn't anything wrong with what happened in that ex parte meeting, despite how I may view it and a lot of attorneys view it. She put that kind of in that ruling. Judge Glanville kind of messed up when he heard the ruling and entered in his own arguments as to why he was not going to recuse himself. So he did those two infractions, and that's how they were able to get the recusal. I am interested to see how she will rule on that. Because they're using all of the things that happened in that ex parte meeting and saying that Kenneth Copeland was coerced and all of that, although I don't disagree with that. But the judge that ruled on that recusal has already kind of set the precedence for that there was nothing illegal or wrong about it. The question is, how will this judge see it? And does this judge have the power to kind of veto that portion of the motion where it seems like it was already ruled? I'm not an attorney, but by any means or stretch, but that is a question that I have. Um, of course, if he gets that motion, the rest of the attorneys can follow suit and everybody's going to walk. Ooh, wee. Oh, my goodness. That's kind of tough. The other thing that I thought was interesting was that piece about Kenneth Copeland's testimony. And when they enter into evidence his interrogation kind of thing that happened a few years ago or whatever, they put all of that into record, and it seemed like that was done illegal by that motion. Like it shouldn't have never been placed into record, and Judge Glanville ruled on that. The other thing that I found interesting was that they were not able to find the signed order where he ruled on it. Y'all know it don't take much for me to come up with a conspiracy theory. It does not take much for me to come up with a conspiracy theory or to bite on one, because my brain be looking, and like that's just kind of how I work. But I did find that interesting, that they stated case law and stated judicial conduct that advised that that was an improper decision, and that they can't even find it in writing. So that he just kind of let it go on, like the jury will hear it anyway, although he didn't sign the motion knowing it was illegal to do that. That's interesting. It is a part of the evidence. And despite the ruling of nothing wrong happening in that ex parte meeting, is there an argument for Kenneth Copeland's testimony and his interrogation, whatever you call it, that being admissible? What is going to happen in this case? I mean, we've gotten to the corruption of it all, and I don't get anything from this new judge that she will kind of handle things the same way. It looks like she will be about the law strictly. She's definitely holding them to the standards of courtroom decorum. So that is going to be interesting to see. It's also interesting that the defense attorney filed their motion to have them to stop speaking in public, which I don't disagree with it. I just find it interesting that that wasn't filed. That could have been filed under Judge Glanville. And the way he's been ruling in this case, he definitely would have had it. So why do you care about it now? You didn't care about it before because they were winning. I guess it's just all speculation. But I wanted to give that update in the YSL case of it all. And the motions are in. We'll be following that up next week. 2024, the judicial systems are banging it out down here in Georgia, and I am here for the drama. It doesn't seem all that exciting anymore now, though, with all that heat that was going on. But I'm interested to see how it all will work out. So it's your girl Duchess. I appreciate having you guys here this afternoon. You bearing with my lives and all of my shenanigans over there in the political arena. Yeah, I hope it fits. This is our channel, so I love to know what you guys think, um and that I'm not punished for it. Anyway, it's a terrific Tuesday. I hope we're ending it on a high note. I certainly am. And I'll be back later tonight to review Big Brother. Somebody getting booted today, y'all. Two people, I think. So that'll be fun. It's also a new show that's coming with some people that I kind of like, and I enjoy watching them. So I'll be bringing that to the table, and we'll see how that kind of shapes out. I mean, we're just in the first month still, kind of, sort of, in this channel. I'm still shaping it. Yeah, just trying to get the people what they want, and you know sharing content. That's what we do. So, thank you guys so much. Make it a great Tuesday, and I'll be back to talk with you soon. Bye.